All right, let's talk about one of the biggest questions any entrepreneur has to face. You've got this amazing idea, right? But turning it into a real, live business means making some huge decisions. And today, we are zeroing in on one of the very first, and maybe the most important one of all, how you legally structure your business. This is the founder's dilemma.
So you have that brilliant concept, you're fired up, you're ready to go. But what's the actual next step? Legally speaking, can you just start selling things? Do you need to find a partner? Should you set up a whole company? Believe it or not, the answer to this one question can define your financial risk for years to come.
Okay, let's really get into this. Because choosing your legal structure, it is so much more than just paperwork. This decision is going to dictate how you get funding, how much personal risk you're strapping yourself into, and even how you manage the business day to day. Getting this right from the very beginning is absolutely crucial.
Here in the UK, it pretty much boils down to three main paths you can take. You can think of them like this. You've got the solo path, for when you're going it alone. You've got the shared path, for when you decide to team up. And then there's the protected path, the one that's meant to put a shield around your personal life. Let's break down each one.
First up, we've got the simplest, fastest way to get your business off the ground, becoming a sole trader. This is really for that entrepreneur who's got an idea today and wants to start trading tomorrow all by themselves with basically zero fuss.
You know, the real beauty of being a sole trader is just how simple it is. There are no registration fees, no complicated forms to fill out. The second you start doing business, boom, you are the business. In the eyes of the law, you and your business are one and the same. But, and this is a huge but, that simplicity comes with a massive risk. It's called unlimited liability. Because there's no legal wall between you and the business. If your business gets into debt, then you are personally on the hook for every single penny. Your personal stuff? Yeah, it's on the line.
Let's make this really hit home. So imagine James here has a cool little bike shop. If his business owes, say, £20,000 and just can't pay it back, the people he owes money to don't stop at the shop's door. They can legally come after James's personal savings account, they can take his car, they could even force him to sell his house. It's pretty scary, and it makes it really clear. The solo path gives you freedom, but zero financial protection.
All right, so what if you don't want to go it alone? What happens when you decide to team up, to bring someone else into the venture? Well, that brings us to our second path, the general partnership. Now check this out. This official legal definition comes from an act written way back in 1890, and it tells us something kind of shocking. A partnership can actually be formed automatically. The moment you and a friend start working together on something to make a profit, the law can say, congratulations, you're partners, even if you never signed a single piece of paper.
Now, just like sole traders, partners have that scary, unlimited liability. But it comes with this extra dangerous twist called joint and several liability. And what that means is, even if you only own, say, a third of the business, a creditor can decide to come after you for 100% of the entire business's debt.
So, for example, say Alice, Ben, and Kara's coffee shop owes £90,000. The supplier they owe money to doesn't have to chase down all three of them. Nope, they can just pick one, let's say Alice, and sue her for the whole amount. It's then up to her to try and get that money back from Ben and Kara, which, you can imagine, might be tough, if not impossible. It really shows you why trust is everything in a partnership.
Okay, so if the first two paths leave your personal finances totally exposed, what's the alternative? Well, this leads us to the most popular business structure in the UK by far, forming a company. This is what we call the protected path.
The absolute game changer with a company is this idea of a separate legal entity. It's amazing, really. Through a process called incorporation, you literally create a new person in the eyes of the law. This new entity, the company, is totally distinct from you, the owner. It can own property, sign contracts, and rack up debt all in its own name.
And creating a company? It might sound intimidating, but it's not as complex as you might think. It really just boils down to four main steps. You apply, you provide a basic rule book, you list who's in charge, and you pay a small fee. That's it. Once that's done, your company is officially born. So why would you go through this process? Well, it's for one huge, beautiful reason: limited liability. This is the corporate shield we've been talking about. It means that as an owner, your personal risk is limited only to what you've invested in your shares.
If the company goes under, creditors can't touch your house, your car, or your savings. Your personal assets are safe.
So, when you see all three options laid out side by side like this, the founder's dilemma becomes really clear. The sole trader and partnership routes, they're super simple, but they put your personal life on the line. The company, it gives you that amazing financial shield, but it costs you a bit of complexity to set up. It's this fundamental trade-off, simplicity versus protection.
Now, at this point, you're probably thinking, okay, case closed. Forming a company is obviously the best choice. But there's a fascinating wrinkle here. The legal model that a company is built on was actually designed with a very specific type of business in mind, and it's probably not the one you're picturing.
A really important study by a researcher named Friedman uncovered a staggering fact. Just look at this number, 90%. That's right, a full 90% of all companies in the UK aren't these massive, sprawling corporations. They're small businesses, startups, and family-run shops.
And this gets us right to the heart of the problem. You see, company law is built on the assumption that the owners, the shareholders, are separate from the people who manage the business. It's a model designed for giants like BP or Tesco, but for 90% of companies out there, the owners are the managers. They're the same people running the business every single day.
So you end up with this one-size-fits-all situation. You have a legal framework that was built for massive corporations with all these rules about annual general meetings and separating powers, and it's being used by small businesses who find it all a bit complex and, frankly, kind of a hassle.
And this leads us to the final and most critical question of all. For that huge 90% of small companies, is that corporate shield, that limited liability, the main reason they incorporated in the first place? Is it actually as solid as it looks? Is it a guarantee?
And here is the final twist. The Friedman study found that in the real world, when a small company wants to get a loan, the bank will almost always ask the owner to sign a personal guarantee. And with that one signature, the entire corporate shield just vanishes. The founder is right back where they started, personally on the hook for the debt. And that reveals the true founder's dilemma. Even when you choose the protected path, that protection is never, ever guaranteed.